Hello, everyone. Today I want to talk about a legal case called Federutility and others, a case that shows us a very simple but important problem in the EU energy law, the time that we had still the second gas directive in place. And the question is, what happens when a market is liberalized in law, but not in reality? Because in theory, after liberalization, prices should be set by supply and demand. But in practice, markets are often still dominated by incumbents, and competition is not fully effective. So the real question is, in this case, uh, can a member state still regulate prices after liberalization if the market is now not working properly? And this is exactly where EU energy law becomes interesting because it is not just about removing this state, but about defining when and how the government can still intervene into the market. All right, let's turn to this case and set it up properly because this one is really useful for understanding the tension at the heart of the EU energy law and how far liberalization went and how far public intervention still remained possible within the Directive 2003/55 and how actually market was not working in some aspect that required evolution of the EU energy law. So the case we are talking about was Federutility and others, as I mentioned, the case C-265-08 that was happening in October 2009. And the basic story was very simple, but the legal question behind it was extremely important. What was the case? Well, Italy had formally liberalized the gas market under the second directive, as you see the name here, the Directive 2003/55 EC. And by 1st of July 2007, all customers were supposed to have been eligible to choose their supplier. So in theory, the market had been opened up. In theory, competition had arrived. And this could mean that customers were free. But in practice, the picture was much messier. The Italian gas market still had a very strong incumbent, weak wholesale competition, and real barriers to entry. That was the situation. So the Italian authorities decided to keep a system of reference prices for household customers, and it was set by the National Regulatory Authority, the in the Italy, the NRA, and that is where the dispute began. The gas suppliers and their association basically said, "Look, if the market was liberalized, why is the regulator still fixing the prices?" So the question was like, doesn't liberalization mean that prices should now be determined by supply and demand? And that was the core object. Uh, they saw the reference prices as a leftover from the old regulated model, something that was holding the market back and undermining the free choice of supplier that the directive was supposed to guarantee. But Italy responded with a different logic. The government said, all right, the market had been opened on paper, but competition was still not effective in reality. The market was still dominated by strong incumbents. The wholesale sector was still not functioning properly, and consumers were still vulnerable to price shocks. So the Italian government said that a limited form of price intervention was still justified, especially for domestic customers, and specifically as a transitional measure. So the whole case became a clash between two visions of liberalization. On one side, we had these perception that liberalization means market pricing, and market pricing means the end of state set reference prices. But the other side said, okay, look, liberalization does not mean leaving customers naked in a market that is not yet truly competitive. If the market has not yet delivered effective competition, then a carefully controlled public intervention may still be legitimate, basically to protect vulnerable, socially vulnerable classes in particular. Now, that is the practical background, but to understand the legal problem, we need to place it inside the structure of the directive. So let's break it down one by one. First of all, what was the directive trying to do? As we discussed during the lectures, this directive 2003-55 was part of the second energy package, right? And the purpose was to complete the internal market foundation in natural gas. That means that we needed to open the market. We needed to remove monopoly structure and make it possible for customers to choose suppliers freely. This is why Article 23 was so important, uh, because it set the deadline of 1st of July 2003, sorry, 2007, by which all customers were supposed to become eligible to be able to choose their uh, prices, their suppliers. So, in other words, the directive was not just about partial liberalization, it was about full market opening. But at the same time, the directive did not assume that the market would instantly become perfect the moment liberalization was announced. That would have been unrealistic if they wanted to believe it. The EU legislature knew that some markets would still need regulatory support, and therefore they need to have still this public service obligations and consumer protection mechanism through Article 3. And that is the key legal tension in the case, because Article 23 was pushing toward full liberalization, but Article 3 allowed a certain form of intervention in the general economic interest. The question was how these two provisions fit together. In the second step, we had this critical question that what was the legal question here actually? Because the real question was not simply whether price regulation was good or bad. It was much more specific than this normative approach. The question was whether, after the liberalization deadline, that July 2007, a member state could still require a regulatory authority to set reference prices for household gas supplies, somewhere that the market still was lacking effective competition. So the court had to think about several things at once. Was the price intervention compatible with liberalization? Was it justified as a public service obligation? Was it limited enough to be proportionate? Was it even discriminatory? Or did it still respect the internal market? And did it really remain transitional, or was it becoming a permanent regulatory structure in this case? That is why this case is so interesting, because it was not a simple yes or no on regulation. It was really about the conditions under which regulation survived liberalization. So now, the third point was that what was the applicant's arguments? The gas undertakings on the one side, they said in essence that once the market was liberalized, gas prices had to be left to the market. And actually, they argued that suppliers' choice would only be real if customers were allowed to see prices formed by competition rather than by administrative intervention. They also said that the preference prices were not truly temporary in any meaningful sense, even though the Italian law described the measures as transitional. The applicants argued that there was no real cutoff point and that the regime had effectively become open-ended. So, from their point of view, this was not a narrow emergency measure. It was a continuing distortion of the market. And at the same time, they also raised the competition concern as well, because if the regulatory set prices too low, then new entrants could not compete properly. If it set them in a way that protected consumers are ensured, but uh, squeezes the suppliers, then the regulatory structure would distort the market rather than helping. So they saw the measures as contrary to the liberalizing spirit of the directive. And what did the Italian government say? Well, Italy argued that the market had been liberalized formally, but not effectively. That distinction matters a lot in energy law, and Italy pointed to the structure of the gas market itself on this basis, because it said that the wholesale market was still dominated by a powerful incumbent, the Eni company, ENI, you know it, and there was still a lack of genuine competition, which means that household consumers could not simply be handed over to the market and expected to be protected by competition alone. So Italy presented the reference process as a protective mechanism, not as a general uh, mm, uh, measure of uh, distorting the market, and not as a permanent rejection of liberalization, but as a limited intervention, which was designed to avoid excessive price growth and to protect consumers during a period in which market competition had not yet become effective. And here is the deeper logic. Italy was basically saying that formal liberalization and actual competition are not the same thing, because the directive opened the market legally, but the market itself was still not functioning in a way that made the consumer truly free. So the state, in Italy's view, still had a role to play. That is the framework. Now, how did the Advocate General approach the case? There is this is actually where the opinion becomes very rich, because the Advocate General did not treat the issue as a purely technical question of whether price setting was allowed or prohibited, but instead he framed it as a broader problem of balancing market freedom and public service obligations. He started from the premise that the aim of Directive 2003-55 was indeed full market liberalization. That was not in dispute. But he also recognized that the directive did not expect the market to function perfectly from the very first day. So, in fact, one of the recurring themes of energy law in this sense was that liberalization often moves faster on paper rather than in reality. So, the Advocate General treated public intervention not as an alien exception, but as something built into the structure of the directive itself. And the key move was his interpretation of Article 3. So he read Article 3, Paragraph 2 of the second gas directive as allowing member states to impose public service obligation in the general economic interest. including obligations relating to the price of supplies. This means that the directive did not rule out intervention altogether. It allowed intervention, of course, but only under conditions. And what were these conditions? Well, five different conditions. First, the measure had to serve a general economic interest, as we mentioned. Secondly, it had to be compatible with the treaty, especially Article 86 of the European Community at that time. And you know that it was replaced by now Article 106 of the TFEU. Thirdly, it had to be transparent, non-discriminatory, and verifiable. These criteria that we discussed and mentioned during our lectures as well. And fourth, it had to respect proportionality, a fundamental principle in many cases you see. And finally, it could not substantially disrupt the internal market. So the Advocate General said, like, the state may freely regulate uh, price. This was not something that actually he comes up with, but rather it was much narrower than this. His view was something like price regulation may survive, but only as an exceptional, controlled, and justified public service obligation. Now, let's get through this main legal idea one by one. So, first of all, what did he mean by general economic interest? Because this was a really important point. As uh, Article 3, Paragraph 2 referred to public service obligation in the general economic interest. And you remember that this was also something that I mentioned during the lectures at our course. The Advocate General connected that language to the broader EU concept of services of general economic interest. And this concept is central in EU law because it reflects the idea that some services are too important to be left entirely to ordinary market logic, right? And gas supply is one of them because households rely on it. Prices matter, security of supply matters, and continuity matters. This is coming from the or perception of security of supply and its elements, even though there is no legally binding definition, right? This is also something that we discussed during the course. So, back to the main argument, consumers can be vulnerable if the market is not functioning properly. So the Advocate General treated gas supply as a sector where public intervention could be justified if the goal was to protect consumers from unreasonable price growth and preserve access to an essential service at a reasonable price. That is the first big point. Reasonable pricing itself could be part of the general economic interest. And this is quite important for us. Secondly, what was the role of Article 86 again from this EC? Here, the opinion became even more structured because the Advocate General explained that Article 86 now turned to Article 106 of the TFEU was meant to reconcile two things: the member states' interest in using certain undertakings to pursue public policy goods, and the community's interest in preserving competition and the internal market. So, public service obligations were not outside competition law. They were inside the legal order, but subject to limits, which means that the state could intervene, but only where intervention was needed to ensure that the special task assigned to the undertaking could actually be performed. That is the proportionality logic. The question was not whether the state liked the measure, but rather the question was whether the measure was necessary. And this leads us to the third point. What did proportionality require in this context? Well, here the Advocate General made a very practical point. He said proportionality had several dimensions. One dimension was time, because the intervention had to be transitional, right? And if the market later become genuinely competitive, the justification for price regulation would taken uh, mm, uh, a weaker ground and needs to be disappeared. So any measure of this kind had to remain tied to the reality of the market, not become a permanent shelter for from competition. Another dimension was content. The intervention had to be limited to what was necessary to protect consumers. If the state was trying to prevent excessive increases in the cost of raw gas, then the intervention should focus on that component of the price. So it should not regulate more than needed. And the third dimension was beneficiaries. The measure had to be limited to the relevant consumers. And if the aim was consumer protection, then extending mandatory prices to commercial users or other non-vulnerable actors would be much harder to justify. Then the fourth dimension was comparison with other instruments, because the state had discretion, but it still had to choose a measure that was not obviously more restrictive than necessary. The Advocate General here was very careful. He did not say like that member states had to prove that no other solution was imaginable, but he rejected any impossible standard of proof. But he still insisted that the chosen measure had to be reasonably connected to the objective. So the opinion was very careful not to turn proportionality into a straight jacket. At the same time, it refused to let the member state justify open-ended or overbroad price regulation. Then, what was about the discrimination? This was another important part of the analysis. The Advocate General said that public service obligations had to be non-discriminatory, which means that they had to apply in a way that did not distort the market by protecting only some undertakings or burdening only some actors. If the reference prices applied only to the dominant incumbent, for example, then that would raise serious discrimination problems. But even a general rule could still be problematic if in practice it hit suppliers unevenly or created unequal competitive burdens. So the court had to check whether the measure was applied fairly across the sector and whether it created competitive distortions. That is another example of how actually EU energy law does not just care about formal labels, because it cares about how the system works in reality. Now, the last question was that about this Article 3, Paragraph 3. So, what about this article? The Advocate General also made a useful distinction between Article 3, Paragraph 2 and Article 3, Paragraph 3. Well, Article 3, Paragraph 3 was more about consumer protection and vulnerable customers, but Paragraph 2 was the more specific basis for price related public service obligations. That distinction mattered because the applicants tried to argue that the price intervention should be justified as consumer protection under paragraph 3. But the Advocate General did not really accept that as the primary legal basis because he thought that the price setting measure belonged more naturally under paragraph 2 of this article, not the 3 one. So, in other words, Article 3, Paragraph 3 was not the main legal anchor for the measure, but in the same article, Paragraph 2 was considered. Now, let's step back and look at the broader significance of this opinion, because that is really where the teaching value lies. And instead of focusing the final decision, intentionally focusing on the details of argument by Advocate General. This case showed that EU energy liberalization was never meant to be a pure let the market do everything. But the directive opened the market. Yeah, this is true. But it did not erase the role of public authority altogether. But instead, it recognized that role, but it tried to limit it. So the state was no longer the old monopolist who was controlling the sector directly, but it still had a role as a regulator, as the guarantor of public interest, and a protector of consumers where competition had not yet been effective. That is why this opinion is so valuable, because it teaches us that liberalization in EU energy law was not a binary switch, it was a calibrated transition. Markets were opened, but public service obligations remained available as a safety valve. And that safety valve had limits, of course. This is the real core message here. The measure had to be temporary, so the time was targeted. It should be linked to a real general economic interest, and it should be proportionate, non-discriminatory, and you know how many times this discrimination and non-discriminatory feature was mentioned in our course, and it should be compatible with the internal market foundation. So if you wanted to compress the whole opinion into one sentence, you could say like the Advocate General accepted that even in a liberalized gas market, so a member state could still impose transitional reference prices for household supply, provided that the measure was justified by a general economic interest, remained proportionate, and did not undermine the internal market or distort competition. Now, before I close, let me make the teaching point even clearer. This case is important because it shows how EU energy law handled the transition from monopoly regulation to liberalized market. And you see that through our course, through the lectures, we went step by step, especially in the natural gas market, digging into different aspects of first gas directive, second and third, in order to show how actually the market evolution was happening. And now in this case, you see that how in reality this was reflected into a real case. So the law did not assume that liberalization automatically meant perfect competition. It recognized that there could still be structural market failure, especially in sectors like gas, where incumbents were strong and consumers were not truly free in practice. So the judgment did not simply ask, is there regulation? But it asked, is this regulation still justified within the logic of the internal market? You see the difference? These are the two different approaches, actually. And this is the real lesson here. The Advocate General's answer was basically yes, but only in a tightly controlled way. And this is important for us to recap how actually it was mm, uh, basically limited by the condition that here I already explained. So uh, that is what makes this case of Federutility and others a fun, fundamental case for understanding the relationship between liberalization, public service obligations, consumer protection, that all we tried to discuss and address here in this case and in general, in a broader sense in energy law. So if we step back and look at the case as a whole, the story was like this. The gas market had been opened up in law, but competition had not yet become fully effective in practice by the time of the second directive, and even by now, you know the story how the price was affected by the geopolitical factors. If you have followed, for instance, story about Nord Stream 2 and Opal case. So Italy responded this by keeping a transitional price mechanism for domestic customers. The legal fight, though, was over something else, whether that the measure was still compatible with Directive 2003/55. And the Advocate General said it could be, but only if it remained limited, if it is justified, if it is proportionate and non-discriminatory. And that was the whole architecture of his opinion. So that is basically the case, and that's why it matters for us. It shows that the liberalization in the EU energy market was not a simple project and simply about removing the state, but it was about transforming the state's role from a direct monopoly market controller into a disciplined regulator. And later, you know that how actually even we had a fully independent regulator, the national regulatory authorities. So at the end of the day, I hope you find this case insightful. And of course, you can find the materials on the Moodle. And if there is any question about the case, feel free to write to me, and you can always find me on the social media. Thank you for your attention.